So now we discuss the most popular case, which is Maneka Gandhi versus Union of India. So I will discuss the facts in very brief because most of you are already aware of it. That the passport of Miss Maneka Gandhi was withheld by the passport authority on the directions of the central government. The passport was withheld on the ground of public interest, and she was not given any opportunity of being heard also on the ground of in the interest of general public. Now in the last video lecture I had told you where is the word in the interest of general public mentioned. The advocate of the petitioner made a case in favor of Maneka Gandhi by using Article 14, 19 and 21. Under Article 14, the petitioner claimed that when the government had withheld the passport of the petitioner, they acted in a vague manner, and therefore the doctrine of overbreadth is to be applied in this case due to the vagueness of the action. Now, the vagueness of the action is alleged on the basis of the vagueness of the word in the interest of general public. Under Article 19, the petitioner claimed that she was having a freedom of expression and also occupation. So, therefore, having a different political view shall also be protected. And it was within her freedom of expression that she wanted to move freely in the country and abroad. The petitioner also used Article 21, by which she was claiming that she had a right to move abroad, which cannot be restricted on the basis of an invalid law. Therefore, this case gives rise to two important questions. What is personal liberty under Article 21? And what is the procedure of law mentioned under Article 21? Now, it is important to note that whatever will be the meaning of personal liberty, it is going to affect the meaning of the procedure of law under Article 21. If we historically decode what has been said for the purpose of the word personal liberty under Article 21, we will first go to the case of A.K. Gopalan. Now, A.K. Gopalan, according to the current interpretations of the Article 21, laid a narrow approach of interpretation for the purpose of Article 21. It said it only relates to the laws for arrest and detention and nothing more. It laid down the theory that Article 21 is different from Article 19. Article 19 lays down the essentials of freedom, but Article 21 and 22 are related. So, Article 22 lays down the aspects of preventive detention, and that only applies to Article 21. Therefore, they said that Article 19 and 21 are mutually exclusive. It was Khadak Singh case in which it was laid down after referring to many United States cases that liberty shall not mean mere existence. Personal liberty as a term is a compendious one which includes all the aspects of liberty. It also referred to the preamble of the Constitution, which lays down that the aim of the Constitution is to assure dignity to each individual, and hence the word dignity comes to be added to the interpretation of personal liberty. The majority, however, said that Article 21 will contain all those rights which are then carved out and made available under 19. Therefore, again claiming that the rights of 19 are different from the rights of Article 21. However, the minority view of Khadak Singh laid down that 21 and 19 are not carved out from each other. There are overlapping, and this aspect has been very well then explained under the R.C.Cooper case, which again is the bank nationalization case, which we referred in the last lecture also. The most important statement of R.C.Cooper is that Part 3, the whole of the fundamental rights, weaves a pattern of human rights. So when R.C. Cooper says that it weaves a pattern, then it means all of the fundamental rights are related to each other. Now, it is a fact that after this decision of R.C.Cooper, many of the laws which were restricting the rights under Article 21 were tested by the reasonable restrictions mentioned in Article 19. And two illustrations which have been given in the case is Shambhunath and Haradhan Saha. Under Haradhan Saha, the MISA Act was under challenge, which was also tested under the reasonable restrictions ground of Article 19 and was held to be valid. So after R.C. Cooper, Shambhunath and Haradhan Saha are the examples where the law relating to Article 21 were tested on the grounds of Article 19. If we see R.C. Cooper case, when it says that Part 3 weaves a pattern of human rights, then we can say that 21 and 19 are not mutually exclusive but inclusive. Then we come to the question of what is the procedure of law which is mentioned under Article 21. So the question arises is whether the procedure laid down by the law has to be a procedure tested by the due process of law, or whether the law only means whatever the law is made by the parliament, howsoever arbitrary it may be. Now, the legality part, that if you want to restrict the rights under Article 21, there is a necessary requirement that there has to be a law passed by the parliament. And this has been laid down in Satwant Singh case. And this was the case which held that the right to go abroad is to be interpreted under Article 21, and without any law there can be no restrictions for the purpose of Article 21, and hence the Passport Act was enacted. Now the Passport Act was enacted and a procedure is now provided for withholding of the passports. In the interest of general public is one of the grounds mentioned in the Act of the Passport Act. Now the question is whether this procedure which is established by law is the same procedure which is asked under Article 21. Whether the question of due process be included. Now it was in A.K. Gopalan case that it was directly referring to Constituent Assembly debates where it was stated that they were aware of the term due process but still referred and implemented the procedure established by law standard under Article 21. And A.K. Gopalan rejected that the word law under Article 21 has to be interpreted as just, which means just or due. They accepted the lex interpretation, that is the positivistic point of view, that law under Article 21 would mean lex and not just, which will mean a just or a law which favors due process. Now again we come back to the R.C. Cooper case. As we have read that when R.C. Cooper said that Part 3 weaves a pattern of human rights and 21 was to be tested by Article 19, will it not be again a situation that Article 21, since Part 3 weaves a pattern of human rights, be also tested by the grounds of Article 14? Now, what is the ground under Article 14? That ground is given under E.P. Royaapa's judgment, E.P. Royaapa versus State of Tamil Nadu. In this case, it was expressly stated that anything which is arbitrary is against the right to equality and therefore against Article 14. Now, we have referred to the arbitrariness under Article 14 in very detail. So the question is, if any law which is passed for the restriction of the rights under Article 21 also has to be tested under Article 14. And if the answer is yes, then it will lead to the test of arbitrariness. It will further lead to the naturalistic interpretation of Article 21. So the fairness under Article 21 will be added from Article 14. And we have referred to the concept of fairness under administrative law, which includes the natural law, which is the principle of natural justice. Therefore, reading R.C.Cooper, Article 14 will also be restricting the laws which are made under Article 21, in addition to the reasonable restrictions mentioned under Article 19. The first question which arises is that whether the passport authority is a quasi judicial authority. No, it is an administrative authority. So, whether the fairness procedure will be applied to administrative authority? The answer is A.K.Kraipak, which says that there has been a very thin line of difference between quasi judicial decisions and administrative decisions. Second question: if there is a law which is made by the parliament and it does not mention the principles of natural justice, can it be implied under the law? The answer of the court is that yes, even if the law does not mention about the principles of natural justice, if any right of the individual is affected by such a law, then principle of natural justice will be applied. The government claimed that there are exceptions to the application of rules of natural justice. The court accepted those exceptions, but stated that the exceptions which are mentioned in the administrative law are to establish a fair procedure. It is not to reject fairness. Therefore, even if the party had not given the petitioner the right of being heard while withholding her passport, they can still provide a post decisional hearing for the remedy of the wrong which they had committed. However, we find two additional cases, which is K.I. Shepherd and H.L. Trahan, which had rejected the argument of post decisional hearings on the basis that whatever has been decided in the earlier matter without opportunity of being heard is the same decision which is repeated in the post decisional hearing of the cases. So it does not give any benefit to the party who is aggrieved by the rejection of a prior hearing, because in the post hearing the same decision is then repeated. So now we will see the major important statements which have been provided in the case of Maneka Gandhi. But before that, I would request you to lay emphasis on three important factors. Now, in order to restrict the rights under Article 21, it is required that the Parliament shall enact a law. Therefore, legality is one of the essential grounds. Now, under such a law, if you want to restrict the rights under Article 21, that action will be tested on the grounds of the reasonable restrictions mentioned under Article 19. Therefore, there has to be a legitimate state aim which has to be disclosed while restricting the rights under Article 21. That legitimate state aims may be in the security, integrity of the nation, in public order, decency, morality, etc. Further, if Article 41 is also going to test the law which restricts the right under Article 21, then arbitrariness of the law will be checked. And one of the grounds we have already discussed to test the arbitrariness is the doctrine of proportionality. So, legality, legitimate state aim, and proportionality are the three essential grounds to test the law which has been passed under Article 21 in order to restrict the exercise of fundamental rights. Now, this legality, proportionality, and the legitimate state aim have been accepted as the testing grounds under the Putta Swami cases. So, with this, we finally see what are the important statements made under the Maneka Gandhi case.